Evening, ladies and gents, friends, Romans, countrymen, well-wishers, ill-wishers, whoever. It's your boy Akil again, and I am continuing with my trend of proving to the world that I love the sound of my own voice and hoping to God that I'm not the only one. So let me just jump right into it. Today, I'm actually going to address a legal issue. It's the kind of thing I've been trained to address since I did go to law school. And of course, the main legal news story nowadays, at the moment, is the decision of the Sixth Circuit Court of Appeals yesterday, Thursday, November 6th, 2014, to uphold the same-sex marriage bans enacted by 4 states. Now, since this decision bucks a trend that's materialized lately of courts across the country striking down such bans and requiring the recognition of same-sex marriages, it's aroused a lot of controversy. It's also created what's known as a circuit split, which is lawyers' fancy schmancy way of saying that different parts of the country now have different legal rules that apply to the issue of same-sex marriage. And so same-sex couples and their families across the country are now being treated differently under the law according to where they live. This is the kind of situation that the Supreme Court is designed to resolve the circuit split by taking one side or the other and imposing that rule on the whole country. So whereas the Supreme Court seems to have mostly ducked the question of whether all 50 states and the federal government should have to recognize same-sex marriage and impose a single rule on the nation all at one fell swoop, it seems likely that the court will now have to address this issue, even though it's declined to do so in the very recent past, in the past few weeks, if I'm not mistaken. So let me say up front that I support same-sex marriage. I think it's the right thing to do. And I agree with the rulings that courts have issued so far requiring state governments across the country. And the ruling that the Supreme Court handed down last summer requiring the federal government to recognize same-sex marriage. Now, I've had some qualms strategically in the past about whether it would be a good idea politically for the Supreme Court to rule all at once that same-sex marriage must be the order of the day and to force all 50 states to recognize it, like I said, at one fell swoop. But as a matter of principle, constitutional as well as moral, I think same-sex marriage is the right thing to do. I think that denying recognition to same-sex couples discriminates against them based on a personal characteristic, namely the sexual orientation that's not inherently harmful, that they did not choose, and that they cannot change. So for those main reasons, I think that not only is same-sex marriage the right thing to do, I think that based on the Equal Protection Clause of the 14th Amendment to the U.S. Constitution, it is the constitutionally required thing to do. So, what's my take on some of the issues that this case and a lot of other past cases have raised? Well, there are a few things, a few areas, I should say, where I think the record needs to be set straight. And it has to do with a lot of the rhetoric you hear coming from both sides of this debate at various times. First, I want to address the question of whether the same-sex marriage issue is about a right to marry. Now, those of you who watched my first video from yesterday about the midterm elections and the issue of the right to vote, have already heard me say that a right is something that people are supposed to be free to do or not do based on their own free will. Based on that definition, I would have to say that the marriage equality issue is not about the right to marry per se. I think it's actually about a fundamental entitlement to the equal protection of the laws. What do I mean by that? Well, I think the difference between a right and an entitlement is that whereas a right is about personal choice and people's freedom to do things that they then have to execute based on their own agency and their own efforts. By contrast, an entitlement is all about what other people or other institutions in society, such as the government, owe you. So whereas a right is about what you as an individual person should be free to do, but also what you should have the responsibility to do on your own if you can. An entitlement is about what other people owe you, or about what perhaps the government owes you. Now, I think what the Equal Protection Clause of the 14th Amendment really does is it establishes one of the relatively few constitutional entitlements. It means that people are entitled to be treated equally by their government, that the government should not discriminate against them based on, invidiously based on what the Supreme Court calls suspect classifications, such as race, gender, and the like. If I remember my constitutional law studies correctly off the top of my head, the way the courts have summed up this rule in the past is as follows: similarly situated people ought to be treated similarly. So in other words, the government can't discriminate between different classes of people unless it has a damn good reason for doing so. And the fact that same-sex couples can't, procreate naturally, and a host of other factors that have been cited by opponents of same-sex marriage to justify their stance, those don't really cut it as good reasons to deny the marriage franchise to same-sex couples. Now, there's another reason why I think that framing the issue in terms of a right to marry is incorrect. At the end of the day, what is the real substance of marriage? What is marriage fundamentally about? It's a choice between two people to live their lives together, to share finances, to share assets and other property rights, and essentially to ride or die with each other, if you will, hopefully till death does them part. Now, the actual nitty-gritty and nuts and bolts of marriage aren't fundamentally legal at all. They don't have all that much to do, well, directly at least, with what the government does. At the end of the day, two people who love each other, whether the government recognizes their marriage or not, are free to live together and to live out their lives as a couple that's married in spirit, and that's married in all the ways that really matter for human flourishing, at least on a personal and emotional and psychological level. Where government comes into play and where the law comes into play is that, we live in a society in which governments license marriage. Now, as a libertarian, in principle at least, and in theory, I've always agreed with those voices who say that the government shouldn't be in the business of licensing marriage at all. It should just be a private contract between two people, and the government should treat that contract the way it treats any other contract. Now, as some libertarians, such as a few of those at Reason Magazine, of which I'm particularly fond, have noted, there are a lot of practical impediments to, this total privatization of the institution of marriage. So I'm not going to get into that issue now. But I will say that at the end of the day, people can live out the basic fundamental meaning of marriage with or without a marriage license from the government. The problem is, without that marriage license, they are denied certain benefits that that recognition grants to those who have a marriage license. So if you're a couple living together, there are certain perks, legal perks, treatment in the tax code, parental privileges, the ability to make certain decisions, end-of-life decisions in healthcare and things of that nature, certain perks you get under the legal system that you don't get if you don't have that marriage license. So denying a couple that are married in a de facto sense recognition under the law is a serious matter indeed, because the government is denying them all of the benefits that come with that recognition while extending that recognition and all of its benefits to others. Now, if it's going to make that discriminatory decision based on a characteristic like sexual orientation, that's a matter of grave concern. And ultimately, I'm one of those people who say it's just not justified, it's not the right way to go. Again, for the reasons I mentioned earlier, homosexuality is not a choice, it's not inherently harmful, and people can't change it. So the government has no business discriminating against people based on that kind of personal characteristic. So the way I think that the issue should be framed is in terms of a constitutional, not a constitutional right to marry, but in terms of a constitutional entitlement to the to the equal protection of the laws. That's something that I mentioned to a former coworker of mine who mentioned to me some months ago that he didn't think anyone has a right to be married, that society has the right to decide whose marriages or whose unions it will recognize or not recognize based on whatever criteria the majority of people and their elected representatives deem worthy. But my response was the same as what I've been saying here so far. I don't think it really is about a right to marry per se. I think it's enough for the courts to find that marriage is a matter of critical constitutional importance, given its importance in society and in people's personal lives, and in the legal system. and the real constitutional issue is the entitlement to the equal protection of the laws. If the government were to, implement an orthodox libertarian policy and simply privatize marriage and treat each marriage contract as a private contract rather than as a licensed scheme, and if it were to treat all marriages that way, and not license any marriages anymore, and not grant recognition to anyone's marriage, straight, gay, or anything in between, then, well, that would satisfy the equal protection principle as well, because the government would still be treating straight and gay marriages equally. So it's not fundamentally about the right to marry for me. It's about the equal protection principle, which I don't think is a right per se, because it's about how the government treats you rather than about how you choose to act. It's an entitlement rather than a right. To move on, one of the pieces of rhetoric that keeps popping up again and again in the same-sex marriage issue, in the courts as well as in the court of public opinion, is the issue of the tyranny of the majority. It's the job of the courts, the independent, unelected branch of government, to secure individuals' rights against the frequent hostility of popular majorities and their elected representatives. Now, I agree that that's the case. I think that the courts do and should serve that counter-majoritarian purpose. However, one of the terms that the dissenting judge in the Sixth Circuit's recent decision, Judge Martha Craig Daughtry, one of the words she used was the whim of the majority. That the majority in that decision, on the court, mind you, the Sixth Circuit Court, had erroneously chosen to defer to the whims of the majority when it comes to same-sex marriage. I think that Judge Daughtry was wrong to frame the issue that way, and that everyone else who frames it that way is making a mistake as well. People who oppose same-sex marriage are not all whimsical. In fact, I don't think most of them are taking that position based on a whim. I mean, to use the word whim suggests that people are formulating their opinions on these issues as a lark, just because, for no particular reason at all, as if it were just a matter of personal taste, like whether one likes chewing gum or cotton candy, both of which I can't stand, by the way. But, from everything I've heard from the opponents of same-sex marriage I've met, that's not true. They're not opposing same-sex marriage on a whim. They're opposing it because they have a, sincere belief, and in many cases a good faith belief, that same-sex marriage is not good for society. I think they're wrong about that. And I felt this way for a decade or more, but, I don't have to mischaracterize their position in order to disagree with their position. I don't think they're basing this decision on a whim at all, particularly those who base their opposition to same-sex marriage on religion. I do gather that that's the most popular reason for opposing it. Religion is not a whim. I mean, you think someone who thinks that gays go to hell, or that homosexuality at any rate is a sin, whatever the punishment may be, for those who don't repent of it, they're not acting on a whim. They're not basing this position on a whim. This is serious business for them. And they believe that they truly are living out and serving God's will. That's anything but whimsical. As for those who try to make more secular arguments against marriage equality, the idea that it's bad for children, or at least that we're not yet sure what kind of impact it has on children, again, these are not whimsical considerations. Even if the arguments themselves ultimately fail under closer scrutiny, which I think they do, there's nothing whimsical about these positions. So I don't think it's accurate to characterize opposition to same-sex marriage as whimsical. Finally, and I alluded to this issue earlier, in the past I've opined that we can't rely exclusively on the judicial branch of government to bring about marriage equality. That if the Supreme Court should ever issue a decision that imposed a duty on all 50 state governments as well as Washington to recognize same-sex marriage all at once, there would be a lot of pushback against it. It would re-energize the movement to amend the Constitution to ban same-sex marriage, or at least to overturn the Supreme Court's decision specifically and return the decision to the states. And at some point, we would have to reckon with popular opinion. I've heard a lot of folks in the marriage equality movement argue that, minorities, individuals really, should not have to beg popular majorities for their rights to be respected. Now, in principle, I agree that that's true, but in the real world, all too often, that's exactly what minority groups and nonconformist individuals have to do. Whether you like it or not, the reality in the world is that you have to reckon with public opinion. There's a quote that's often attributed to Abraham Lincoln, namely, "With public opinion, nothing can fail. Without it, nothing can succeed." I'm not sure if he actually said that or not, but even if he didn't, it's good talk. And particularly when it comes to the rights of vulnerable individuals and minorities who buck the societal trend, whether by choice or otherwise, and are thus vulnerable to oppression or persecution from popular majorities. At the end of the day, in a society in which a majority of the population is hostile to a given minority group, that group is always going to have to deal with majority opinion in some way, shape, or form sooner or later. Whether you like it or not, whether they should have to do so in principle or not. I mean, people in the same-sex, the gay rights movement often cites civil rights, racial equality in America as an example of that. I think it proves my point. I mean, the Supreme Court's decision in Brown versus the Board of Education in 1954 didn't wrap up the issue of civil rights in a neat little package. If anything, it kickstarted the civil rights movement. It wasn't the culmination of the movement. Okay, a lot of political struggle had to take place after that, in the decade following Brown versus the Board, in order to establish the basic framework, legal framework of racial equality in this country. And of course, plenty of work still remains to be done on that front to this very day, half a century later. 60 years after Brown versus the Board, mind you. So I think that just goes to illustrate the point that, when you have a vulnerable minority group in a society, there's no getting around majority opinion if that majority is hostile enough to that minorities, to the rights of the individuals who belong to that minority group. So my concern, while I was still in law school a few years back, was that if the Supreme Court pushed too far too fast, the backlash, well, it wasn't even so much a fear that the backlash would cause marriage equality to fail. It was just that, look, sooner or later we're going to have to reckon with public opinion. Sooner or later. We've already been doing it in many cases, and certain states have already recognized same-sex marriage through the political process rather than through the courts. But the point is we would have to continue that struggle in the court of public opinion, not just in courts of law. However, the way things are going recently, it looks like I may have been wrong about that as a matter of factual prediction. I mean, it may turn out that the Supreme Court will hand down just such a ruling, and those parts of the country, mainly the Bible Belt, that continue to resist same-sex marriage may actually ultimately just grin and bear it. We've heard a lot of traditional opponents of same-sex marriage sort of giving up the fight in recent years, or at least focusing their attention elsewhere. And according to what I've read to just today, it now appears roughly two-thirds of American states recognize same-sex marriage in one form or another, and roughly two-thirds of all Americans live in states that recognize it. So while at present we have a patchwork of states across the country, whereby most states have now come to respect marriage equality, whether by choice through the democratic process or under prodding from the judicial branch. And of course, you still have some states that are holdouts. The Supreme Court might actually do what it, I think, constitutionally is supposed to do, require all 50 states to recognize same-sex marriage, and that decision may not be overturned. I suspect that there will be some backlash in the form of, renewed and stepped up efforts to try to amend the U.S. Constitution. If not to amend, to ban same-sex marriage outright in the U.S. Constitution, then at least to overturn the Supreme Court's ruling and allow the states to decide it on their own. But the way things are going now, I suspect that such efforts will probably fail. And frankly, I'm glad. I mean, if my former view ends up being proven wrong on this subject, I'll say hooray, because the right thing will have been done, and a class of Americans that's been despised and oppressed for thousands of years around the world will finally get its constitutional due in this country. So I think that about sums up my take on this particular issue. Hope I haven't bored you all. And again, feel free to leave your comments, both here on YouTube as well as on Facebook, where I certainly am plugging these videos with all of my Facebook friends. Looking forward to hearing from you, and till we speak again.